On behalf of Beyond Law CLC and Symbiosis Law School, Pune, we welcome you all to yet another vilifying session and topic which has its own interest, that is law, judicial process and justice. Amongst us, we have Honorable Mr. Justice A. Mohammad Mushtaq, Judge from Kerala High Court. Those who have been following the webinars of Beyond Law CLC, somehow we have got large number of speakers from the Kerala High Court. That shows the way we have been connected and the boundaries, especially through the present era, is no longer a consideration. And by this fact that we are being connecting through Justice Mushtaq is that as the participants who participated yesterday would remember that amongst us we had senior advocate Mr. V. Giri, who has been a former judge of the Kerala High Court. Without the fact that, if you remember, he said that why don't you bring Justice Mohammad Mushtaq? He's an erudite speaker and an epitome of knowledge. And when we informed him that he's coming on our platform, he said that the way he has his knowledge, we shouldn't restrict him for one of the webinars. And once that word is coming from a person of the stature of Mr. V. Giri, it speaks volume of the knowledge of Justice Mushtaq. And those who have been following, especially during these lockdown times, as to what is the procedure for the virtual courts, what is the procedure for how to use the latest technology, the digital innovation. If one Googles on the net, etc., those who are not connected with the Kerala High Court would find that the innovations in the digital processes being used in the Kerala High Court are certain examples which have been set as a benchmarks in large number of courts. Recently, when we had the webinar, somehow that time was overlapping. Under the aegis of Justice Mushtaq, they had laid down the tones for how we go in the future for this issue. As we said, I was just going through the resume, I found that he's an expert in space and telecommunication law. The students of law and lawyers would find, does this law actually exist? But once you find that a person who is considered to be an expert in the space and telecommunication law, of course, there is, everybody invariably knows. But to state therein that there is a space law gives the flip to the mind that what type of law actually it has been evolving and what type of knowledge the judge has. His private international law, alternative dispute law is again one facet which invariably the student of law, lawyers and the judges are knowing. And interestingly, besides law, he's also been closely associated with mediation. Mediation, though alternative dispute law and section 89 of CPC are interwoven amongst each other. So having so much of immense knowledge on different spectrums of law and beyond law is what motivated us to ask the Honorable Judge to kindly come on this platform to just give us the little peep into the knowledge, what he has in this. But as after this webinar and during the webinar, we were requesting him that we would like to have definitely a different session from him. He has been a keynote speaker. His various papers have been published. So it's all easy said than done while you express that he has so much knowledge and so much papers being published. Actually, it's very, very difficult to match up all these. It shows the amount of energy he has for the purposes of the judicial. So without taking much time, I request, sir, to take the things forward. All these participants are more keen to hear you rather than me. Over to you, sir.
Thank you, Vikas, for the nice introduction about me. I don't think I deserve all the encomiums based on me. Well, as far as the Kerala is concerned, there is a joke always said, Kerala, you can find even running a tea shop in Moon. So you don't find, there won't be any surprise. The Kerala is also the part of the webinar, in every webinar and conducted in a nook and corner of this country. Scarlett is always passionate about seeing elsewhere. So they take up the challenges. Of course, if time permits, I can join with you any other webinar being hosted by you. As of now, of course, our judicial work is minimal, but being the chairman of the computer committee, E-committee of High Court, I have a lot of work, administrative works to do, because we are in the transition process. So we are just looking forward to make changes, revolutionary changes in our platforms, because people badly needed that. Today's subject is, of course, it's kind of an abstract idea. We need to speak. It may be boring if you have I make a long lecture, but I rather intend to speak from about my heart, from being a judge for the last more than 6.5 years. So it would be my pleasure to share my thoughts with you, what I understood the judicial postures and how it formalized justice through that process. Whereas my attempt to share my thoughts, rather than like any other, not like an expected way of an academic try to expound this topic. Well, after becoming a judge, most perplexed question for me is what is a law and what is a justice? Till I became a judge, I have no issue of understanding what is law or law. But once I became a judge, I think it's a very complicated point to understand, because whenever focus is on justice, so it is difficult to understand the law. It's always an eternal question: what makes law? Who makes the law? What is a justice? This is always perturbs a perplex the mind of the judges. As a lawyer, I just look upon the law as how to formalize my prayers or relief for my client, nothing beyond for me. I try to fit facts into the law and get a relief. So I just plead for the lawyers, for litigants in the court, as like any other do. And I try to convince the court that is a law. An academic thing in a different perspective. They always think in terms of philosophical questions being answered through the legal philosophers and political philosophers. So they try to justify, they try to find out law, what philosophers had argued on the front of law, what the political philosopher laid down on the justice system. So the stream of law is varied in accordance to the perceptions. Even the judge think in terms of justice, how the justice could be served within the frame of law. That's there is a perceptible differences between the different walks of people who deal with the law. Perhaps it's very interesting to discuss this topic amongst the academics, the students, the lawyers across this country. While when you talk about law, everybody say that, as a student may say that legislation, like Austin in her outlook of positive command of a superior to the inferior. But it's only part of law that is we understood the legislature, what legislators make. We have international law, we have a personal law, we have a customary law, we have a common law. These are all part of the legal system. So defining law is not easy. How do you understand the law is might be more complicated. You know that law exists even prior to the formal documentation or formal legal instruments being placed, like constitutions. Law, they exist in a society. People follow the law. You might have heard Mr. Justice Naidu, how he expounded the evolution of the common law principles. Where the law followed the people, not the people followed the law. So how it has evolved in a society. So there was always yearning for an established principles in a society in a structured form. So this people try to encapsulate in different varied manner. If you find the legal philosophers have differed on what is the law and how the justice system should be structured. So how do you understand law? Somebody asked me, is there any law which prohibits murder? Is there any law which says none should steal? How does you say that? How do you say that? Is there any law? But there is existent obligation, as you know. In every society, there is kind of a mutual obligation existing in the people. Law only calls upon when through the penal law to answer if there is a breach of obligations. That's how we formulated penal law. But it's a very pertinent question. Is there any law which says one should not steal others' property? There is no law you can find where it's prohibiting in a murder. It's only speaks about consequences. So in a way, understanding the law is always difficult in such sense. The social structure become relevant. The political structure, it become relevant. So understanding the law is in a different perspective always is something throws a challenge is the court as well. So always there is a dilemma in defining law. You can find history in how the people have differed. There are people called John Locke, who's an advanced theory of naturalist, humanist principles. There are theories who follow divine laws. They said law is a command of the God. This is how theocratic government is formed. There are theories which is called based on social contract theory. So on, people advocated on. There are positives like Austin, the Kelsen's theory of law. The legal philosophers were differed in understanding the law. Every have understood a different perspective. If you read the Republic of Plato, there is a discussion between Socrates and the Athenians. They understand what is justice. The Plato's Nicomachean refers to certain kinds of principles of justice. So they have seen the law in a different perspective. All have a difference. Now, what is the relevance? Of this discussion is perhaps most interesting. As I said, for the last 6.5 years, I'm being a judge. What I miss in the court really understand the creativeness of the lawyers. Lawyers have tend to become stereotypes. They are all become the prisoners of precedents. They just simply follow the precedents and make their arguments in the courtroom. There is a lack of creativeness in the courtroom. That is the reason I said when I asked by me, because I choose this topic. The lawyers is fundamentally a creative creature. If they lack creativeness, they can't be called as lawyers. Even today, in the era of technology, artificial intelligence can give a better opinion in advice. So lawyer can't be equated with the machine. They are superior animal. So they have intelligence. They have a creative space. They have to use that creative space. So fundamentally in courtrooms, what we lack is creative space. There is no intellectual debate on issues and understanding the point of law. So lawyer has to turn to be a conceptual thinker and advance their argument in those points. Perhaps my whole attempt in this session to deliberate on this point. The precedents, as you know, lied on the Queen Latham, the famous judgment, that it is only relevant for what they said on the particular facts. Each fact differs. Case laws, of course, is relevant in common law followed countries. But you know that varied circumstances in a case, a cause of action arises. In those circumstances, we have to think creatively and develop our ideas and concept of law to expound an argument before the court of law. So my friends, particularly young lawyer friends, you have to think in a different way. Don't try to be stereotyped. Try to advance arguments based on the concept and develop your arguments before the court. So as I said, there is always a dilemma in regarding defining law. In Richard Dawkins' book, Laws Empire, he discussed about two case laws, but that is very interesting to open our debate. The first case is Elmer's case. Elmer's case is a very interesting case because Elmer's grandfather bequeathed a large estate to his grandson, to Elmer. Thereafter, grandfather remarried, fearing that he will rewrite the will or make a codicil or he may do to cancel the bequest. The Elmer murdered his grandfather. So as per the plain law, bequest has to pass on the death. The Elmer would be entitled to inherit property. There is no law which say prohibit murderer being inherit the property based on the bequest. So this was a perplexed question before the court in the US. There was a majority opinion, dissenting opinion. Majority opinion said he cannot inherit the property even in the absence of law. But there was dissenting opinion, he would be entitled to the property. Perhaps this is something which always perplexed the court. When in terms of plain law, you would be able to argue it is entitled to inherit the property. But he's a martyr. He wants to get the benefit of the martyr, his wrongful actions. So this is something which a judge has to interpret when formalizing justice, because judge's consensus is always justice. He should not import his personal philosophy. He may be a moralist. He may be a person who has kind of perception, but still, judge has to think. In another case, in the California divorce case, where a divorce petition was filed before the court in California state, it was on the ground of adultery. I think it was instituted by husband against a wife or something. But there was overwhelming evidence to prove that other spouse living in adultery. Normally, this is easy ground for a court to grant divorce. But court declined the divorce on the ground that there is equally overwhelming evidence to show that the plaintiff, the applicant before the court, is also indulged in adulterous life, provocation. So when you look at those balancing at court, say that both leading in adulterous life, court should decline the divorce. This is how the California law, family law, was later amended to incorporate no fault ground for the divorce on the ground of adultery. But look at the plain meaning of the law. Plain meaning law says when there is a ground of adultery, when it is proved the satisfaction of the court should grant divorce. So in spite of the evidence, court declined by pointing out to the evidence brought by other side, respondent, to prove that applicant is also leading a life of adultery. But when you look at the plain reading of the law, court has to grant it. But it is not the justice. Is it that is the justice? That is something which perplexes our mind as judges, as a judge. That's what I said. The judge's mind always works in terms of justice, not in the plain letters of law. Now, how this debate has to be taken to, that's perhaps more interesting. You know that there are two sorts of legal philosophers whose debate is always perverted in the courtrooms. One is HLR and Dawkins. Dawkins is a disciple of HLR. HLR is a hard positivist. He says his open textures theory because it says the judges fill the gap. The judges fill the gap. And in hard cases, the court doing the justice by filling those gaps. But on the other hand, Dawkins advanced. We repel this argument, says judges is not making law. Judges actually decides based on the principles. According to the Dawkins, legislative always have a respect for the principles which already exist in the legal system, even without there being a specific incorporation or reference in the statute. Because always these principles is matters. For example, we always quote natural justice as a principle. Even without an explicit reference in any of statute book, we always quote it because these principles always exist in the legal system. So the Dawkins advocate this idea, like he says, legislators have always a traditional respect to the traditional principle of justice unless expressly mentioned contrarily. So according to him, statute would form part of larger intellectual system, and as a whole, law as a whole should be construed to make larger system coherent in principle. That's what his argument. So if you look at his argument, he says, if we just take it to the Elmer's case, which I referred, which a murderer to benefit, in order to obtain the property covered by a will, he kills his grandfather. So there is a principle he calls, says that no one should benefit from his own wrong. So he says this should be read into the statute, though it is there not explicitly. He says, Dawkins' argument, these general principles always govern the statute. So even there are different sorts of process, you will find some answers when you make argument in a courtroom. These principles we cannot ignore. For example, H.R. Khanna's dissenting judgment in famous habeas corpus case, even he says, and even without Article 20, when suspended, there is a law in the law has been followed. No one should be deprived because it's a natural right. If you read the John Locke's treatise of two government, you find he's an advocate of natural rights. He emphasized on the natural rights of human. So even without formal declaration through constitution, such right exists. So this is something which we miss in the courtroom nowadays. So legal system works as a whole in a structured formula, not explicitly through the statute book, but even without statute book, there are some principles exist in the court. There are principles exist. Finding these principles is always a challenge to the lawyers and judges. Perhaps this kind of platform should be used to open up such arguments when you to advance before the courts. So, well, we're moving forward from there. We just understand some of the philosophical exposition of justice. In H.L. Hart is in a famous book called Concept of Law. He said the primary rules and secondary rules, the union of the primary rules and secondary rules is a foundation of the legal system. Primary rules refers like in certain obligations. For example, I said earlier, in a society, even without there being a statute or any other law, everybody respect others' right. So one should not kill other, should not commit any murder. That's kind of obligation, each otherwise derived from the natural. So these are kind of primary rules. And there are secondary rules. The secondary rules are related to the primary rules. Secondary rules are being classified at different levels, like rules of recognition, rules of education, rules of changes, so on. So he says, according to H.L. Hart in the concept of law, he says this union of these rules are the foundation of the legal system. So in that process, according to him, judges is a part of rules of education. He just trying to find out original meaning of the law's obligations. This is how he defines the process of education, how the judges, through the open texture, filling those gaps in hard cases. Now, Austin, you know that many of heard in the law students how the Austin defined It's like a command of a superior to an inferior. So different approaches made. But Salmon has definition. Salmon, according to Salmon, the justice is the law is a promotion of justice, the framework of law. The aim of the law is, according to him, the justice. Austin has no botheration of the end of the law. Absolutely no consequence, like in Kantian ideas. Absolutely, whatever the end of law is being secured according to us is just a superior's command to the inferior. So we find the difference in approach. So philosophers differed in analyzing the justice system. The Greek understood the truth. The Greek concept is that justice is also a virtue, and even how dharma embodies certain principles of justice. They say that dharma is an internal, external contact. Of course, I need not to dwell on every aspect related to it. But I'm only brushing to this area. It says that ideals of justice differs in concept, differs in society. Even if you look at Amartya Sen refers to idea of justice is nitya and nyaya. Perhaps way of understanding the concept of justice in different perspective. Nitya relates to the organizational propriety as well as the behavior of an entity. Nyaya means is connected to with nitya and niti, with images how and particular lives of the people are actually able to lead. In a democratic setup, niti is matters. What is a niti? Is an institutional propriety. The institution is very important a role in a democracy. That's why we trust on the independence of judiciary always. If the institution fails, that means there is a failure of justice. It is not the capability of the judges to deliver the justice in terms of passing judgments of decided dispute. Ultimately, the institution's credibility rests on the confidence people placed on it. That's what I'm saying the justice system is rest. The moment you lost the institutional credibility, you can say that there is the concept of the justice failed in such society. So the propriety of the institution is very important in the ideals of formalizing the justice system. So you find in a democratic setup, this institution is having fundamental role in shaping the concept of justice. The institution not necessarily to be referable to the judiciary as such. It can be even to executive aspect, because people's expectation is a different level of delivering justice. Is always depend upon the sphere of relationship they may have. In court, they have the relationship based on that dispute. In relation to this governance, in terms of the governance. So aspiration of the people in those level always depend upon the credibility of the institution. So the idea of justice always may have relevance depend upon the nature of the institution, which the subject have a relation with such institutions. I just do not want to refer to the ideas of different perspectives, Kelsen's ideas, Nozick ideas. There are different ideas related to the justice because it cannot be relevant. It's not an academic session to understand the theory of justice, but it's the process, very nature of this platform is to create a place for a dialogue, how the justice should be formalized and shaped in courtrooms when the arguments have been advanced. So I just skip some of the ideas because though I have prepared a note to refer to those ideals of justice, I'm just skipping about those areas. Now we can find the very nature of arguments advanced in the courtrooms not necessarily depend upon what is written on the statute book or what is written on the Constitution. If you look at the Constitution, how do you will come across egalitarian ethos has been proclaimed in Article 14, 15, freedom of expression thought referred under Article 1925. The liberty is defined and protected under Article 21, and cultural rights under 29, minority rights under 30, different aspect of it. But it's all our contextual relevance. So the arguments always to be one would make in the courtrooms, not necessarily on the abstract ideals, but in explain this ideal in the context. For example, a couple of weeks ago, I think Justice Sikri had a lecture on the proportionality principles. I heard it. He refers to proportionality principles. If you look at the Constitution, don't find the proportionality. The proportionality, in fact, is a principles referred in the Aristotle's Nicomachean ethics. But down the age, people followed it. The proportionality while referring to the punishment, disciplinary action. So you won't find it neither in the Constitution, but well, advancing the arguments, you place reliance on Article 14 and place reliance on it, and say that action is not proportionate. So this concept always binds the court. Similarly, the basic structure theory, you don't find anywhere in the Constitution, but for the argument of great doyen of the bar, Palkiwala, this would not have applied in the Constitution. This would not have been a landmark judgment. So this idea of basic structure theory might be a foundation may be found in the German Constitution of Eternity Clause. But you find these arguments have been advanced to streamline the judicial process to advance the justice. So you won't find basic structure arguments anywhere, point in anywhere the Constitution. But court followed that. So court has to think in certain terms of measures to find justice. Similarly, the strict scrutiny theory, which is, of course, is a proponent in American Constitution, especially when matters related to the fundamental rights. So you will find so many areas of arguments being placed before the court, not if we will not find place in the Constitution or in the statute book, but these are arguments advanced to streamline the course of justice. There are areas other than these arguments which have been raised before the court, where often we forget these areas. For example, restorative justice, this concept, this is restorative justice, the concept is evolved to rehabilitate victims through the assistance of offenders. Of course, this is a concept, kind of through the conciliatory process. But we don't find restorative justice being used in the court. The courtrooms, the criminal courtrooms, especially, I would say, is been ordained or focused only to punish an accused who is an offender of an offense. Why? Because lawyers lack the idea of advancing the cause of the victim in the courtroom. You know how many sexually abused victims are suffering by the trauma they had undergone. The child victims, absolutely, they don't have place in the system. So it is lawyers' duty to advance this cause like a restorative justice, not in real terms of restorative justice by involving the offenders, but in any other platform. We have a system on how the compensation being paid to the victims and through the process by amendment to 357, Criminal Procedure Code by incorporating 357A. But I'm not on the point. I said lawyers seldom take up these causes of the victims. So idea of the justice evolved this based on this concept. As I said in the earlier, the idea of justice not normally found the statute book or Constitution or it related. It goes beyond the rooms, the books or statute you rely, or the process on which it is ordained. So it has to come from elsewhere, as it in the like of applying the principles of proportionality, as like in the applying the principles of basic structure doctrine, the strict scrutiny doctrine, like any other venture reasonableness. So idea has to be imported to promote the cause of justice. It is where the lawyers fail, I feel. I said that this is where the creativeness of the lawyers being found lacking. So the conceptual lawyers will not miss these ideas. So victim has to find a place in the courtrooms merely by in terms of offering them some pittance by off or whatever the amount being offered to through compensatory scheme. But they should be there. The injury which suffered should be repaired. So we have to develop the idea of restorative justice in such courtrooms. Well, I said this kind of interpretive process through the meaningful approach to the interpreting statute and constitutional lawyers make. But it should be contextually relevant in a society in which legal system principles evolve. I find there is a tendency to follow blindly the Western liberal values while making the advancing points or grounds or exposing level in the courtrooms. Perhaps brief idea of this is necessary to equate in Indian context, especially in this, the legal system which prevails in India. Our constitution, of course, it is said we have borrowed principles from the different constitution. It's true, we might have formalized by borrowing those principles. Like equality and concept, secular concept, the word concept relating to liberty. But you cannot say these are ideals aligned to the Indian society. These concepts very much exist in the Indian traditional society. This is not foreign to the Indian tradition. Formalization of this concept through borrowing is different from that attributing says that we are not followed in the society. Even without constitution, formal constitution, the society has either to follow kind of concept and the principles which we now is cherished through the constitution. Perhaps we need to take some caution while following blindly the liberal values expounded in Western countries. You know that in Western concept, the liberal values they came into existence as a result of the challenge they made to theocratic or divine form of the government. It was a challenge against the church, followed by the Renaissance and in the period of intelligentsia. The John Locke, in his book Treatise of Two Governments, he rejects the idea of theocratic government because theocratic government believe it's established by divine commands. The justice system is established by divine commands. So this book, John Locke rejects this idea and he put forward alternative ideals of naturalist. From there onwards, there is a march of liberal views in Western jurisdiction. So they divorce completely from the divine justice. They created natural principles of liberal values. So rights, obligations is essentially had basis in the naturalist ideals. So those liberal values, if you try to emulate without there being a filtering of those values in Indian context, it may have some kind of repercussion now values which have been followed. The naturalist ideals is reject the divine, the kind of divine justice because they want a complete separation of church from the secular. This is how the secular concept is evolved in the French. They expound the principle of laicite. That means they don't accept the secularism. Of course, they accept the secularism in different countries, but they reject in this public space. How secularism totally different, understood and different. Similarly, all liberal values, it's a rejection of, it's as a result of separation of religion with natural ideas. But Indian society is primarily a society developed through the religious practices, tradition from Imam, Smritis, all kind of literature exist in India. The traditional principles which have some kind of foothold in our concept. While involving liberal values, can we forego those liberal values and those traditional practices, except to the contrary which exist in the Constitution? Constitution also permits certain kind of interference with the religious belief and practices if it is repugnant to the health, morality, those principles. So is it an open question for or whether it's possible for us while following the liberal values, just to forego the traditional practices as existing in our country? Perhaps that is a way of we have to think while interpreting many of issues that has evolved under the as the social issue, not as the political issues. As I said in the secularism, we never proclaimed the secularism in our constitution when it was adopted, because countries, the tradition itself is based on the secularism, a capacity of accommodating all types of religion. They accepted the foreign religions, Islam, Christianity, without any mentions. The tolerance is at all level. So that country need not be taught about what is a secularism. That exists. Of course, that is formal declaration came in subsequently in 1972. Similarly, we have all kind of values. So while interpreting our constitution in terms of civil rights, social rights, are we expected to forego our traditional practices is something which I just want you to ponder about. It's something which really requires a debate on this. So that's why I said the liberal values cannot be blindly followed in our social context. Perhaps we have to take a caution and guard against those approach. Well, before I sum up, I'll just take over some of my approach, my idea of the subject. The judicial process had a paradigm shift from the period of British till the period of technology. The justice dispensation in the British period, during the period of colonization, was primarily confined to the criminal and civil rights of the parties. Political rights have been hardly addressed, even though Government of India Act 1919 addressed certain issues with the political rights of the province and union. 1935 Government of India Act hardly addressed any rights, civil rights or political rights of citizens. So it was formalized and confined to the courtrooms in criminal and civil courts. The post-constitution, you find a shift. The people try to assert their political rights, civil rights, social rights. This is how the constitutional law developed from A.K. Gopal and Maneka and the Keshav and the ADM, Jabalpur. Constitutional history speaks about how the growth, how the constitutional interpretation of the various rights as envisaged made India as it today. But you find the advent of globalization after post-90s. We have a host of legislations like Information Technology Act, Arbitration Act, IP laws, many of laws. These are laws made in the country based on the super norms dictated elsewhere, like constitutional mode. The basic idea of change has been affected through this legislation is to promote economic interest, to create a market economy, because in a globalization, the very idea of globalization, to create a market economy without there being any borders. In market economy, interest is of persons who are involved in the market. They just want to protect their market interest. So economic interest has reshaped in the market economy through host of different legislations. That is the reason international bodies try to impose these super norms to the country and adapt. Now, another dimension we faced is through the technology. The technology had a perverting effect in our every aspect of our life. Now, these two areas, we were not able to grapple ourselves and understand nuances and intricacies and develop the concept of justice. Most of the decisions related to the market economies came as a policy from the union government or whichever the government is involved. So seldom court interfere with the policy decisions on the ground that it is beyond the reach of the court, interferes with policy decisions. So reference to the executive wisdom always prevails in the court, except in the cases of the two cases where the Supreme Court interfered. It opens up a different mind. I just not been oriented through the for citizens. Now the which is three aspects. First is related. What is that? We were able of by different right in the social political right will.
So kindly check it out. I think
not
your
defined
screen is
yet.
slightly frozen. Sir?
Is it talk?
Sir, now even the video has gone. Probably you will have to log in again.
Yeah, I'll do that.
Meanwhile, the participants can post their questions, and those who want that they should be unmuted, they can raise their hands in the chat box, or they can write that they want to get themselves unmuted, so that once the question and answer session is started, the questions can be taken up accordingly. So Joy, I can unmute you, and you can pitch in what you have learned so far in this process. I'm just unmuting you till Justice Mushtaq joins us. So Joy.
Yeah, in fact, there are a lot of takeaways from today evening's talk. I think the Honorable Judge really spoke from his heart, and the confidence of the people in this institution. Ultimately, we may come, we may go, the institution is going to continue. And that is the legacy that is going to remain.
So he has joined up. So before we take up, so welcome back. I think. I will check out.
Vikas can't hear you.
Sir, try speaking something because. Hello. Sir, sir, in fact, the screen is not reflecting the speaker on your side. You can just show. I'll just try. Just start. Unmute. So Joy, you just take over. I'll just check it out.
No, that is why I said that the takeaway of today evening, what His Lordship spoke from his heart, was actually the confidence of the people and what is the legacy that we are going to leave behind. See, the institution, the reputation, the confidence of the institution has to linger on. And that is what is most vital. So therefore, what His Lordship said was that on one side you have the law, and on the other side, you have what is actual justice, which actually the people are waiting for, the justice delivery system. And that is what really touched, I think, all of us when he spoke from his heart, apart from giving examples of foreign instances. And the fact that the role of the judge is to iron out the creases, as Lord Denning said. There may be some loopholes here and there. And that is what is justice. And that is why inherent powers are vested under the CPC and CRPC with our honorable high courts. Of course, Supreme Court is different, but as far as the high courts. So that is what is most important. And that is what really impressed me. That the judge spoke from his heart.
So Joy, I think, meanwhile we are taking forward, as he said that there has to be balance maintained between the traditional values, liberal values, when the issue is to be adjudicated. So his entire crux is that we should all, hello, yeah, with your name, okay, I'm unmuting you. You join through the mobile. You join through the mobile, Mohammed Mushtaq. So try unmuting at your end also.
Yeah.
Yes, sir.
So now it might be audible, right?
Yes,
Yeah.
sir. But it again shows that the person, why we say that you are well connected with the legal technology innovation, because sometimes it so happens that the speaker, like we had the present occasion of that the screen being frozen, but that shows the way and the challenges we will take after the session and the question answers. What are the challenges once we take to the virtual platform? And since you are part of that Kerala bar, we will Kerala High Court, we will take those questions also.
I'll just sum up my points so that we can go for a discussion on this, because I just see the future of justice related to three aspects, as I said. One is creating an economic order. Second is the use of technology. Third is related to shift from adversarial to collaborative approach in dispute resolution. Because the youngsters are here, I just want to advise them how you look. I need to look upon the future. See, creating economic order, as I said, absolutely, we have not developed any jurisprudence fitting the economics into the constitution. How constitution speaks about socialism, I'm not saying that it's not practical or not. It's a kind of perspective of political call to be made. But certainly there are rights of the people have been affected on account of economic changes being affected, policy being followed by governments. It's for the legal community to develop economic concept to withstand any of the challenges withstand those challenges made up on the people. For example, people face kind of a challenge through the market monopoly of life-saving drugs. People now would say that they have remedied through the competition law. Similarly, there are many areas where people could sustain those challenges. But in terms of constitution, we need to develop a jurisprudence. James Buchanan, the very noble laureate, he's written a book on constitutional economics. Hardly we've heard about in our context. We have not dwelled upon the economic aspects of the constitutions. We have championed those causes of political, civil, social rights, but we never addressed the issues relating to the economic rights of as embodied in the constitution. Perhaps we need to develop the concept related to the economic justice of the people. When there is a wider gap between the rich and poor, when there is no fair distribution of the wealth and office of the available to citizen, certainly it's a matter to be addressed through the economic order. So we need to develop kind of jurisprudence, creating an economic order in this country. That's where the future of the justice will be focused. Because as I said, there is a complete shift from in the advent of globalization to the market economy, where the market interest is alone considered. Maybe government is entitled to follow their policies and procedures as permitted under the constitution. But once it infringes rights of the citizens in certain level, there is an economic empowerment. Certainly it has to be answered through the constitutional scheme regarding in creating an protecting economic rights of the citizen. It's for the younger generation to take up this task. Second area is the use of technology. Technology is not a mere aid in the process for rendering the justice. Future of the justice would substantially depend upon the use of the technology. The technologies could be the medium where it can include the persons who are otherwise marginalized, excluded from the mainstream justice system. Technology could identify the people and the very varied situation in which justice can be rendered, either through the physical motor system or online. So today, the people are talking about every sector as a service sector, like even the legal field, the legal system or dispute resolution, whatever the system in exists in the system, in physical motor. People are talking about its relevance in terms of service. So technology is would really create changes to make any type of legal service readily available to the citizens. So tomorrow's justice system mainly will be focused on the approach, the citizenry approach, which may require through the platform of technology. This is the second aspect I want to stress the youngsters need to take up. There is plenty of opportunity for you to exploit the platform of technology for the development of the country, like creating legal instruments or whichever the areas which may be required. It's for the youngsters, young generation to take up this onerous task, use of the technology for rendering justice to the people. The justice, as I said, is not a mere monopoly of a court as an institution. Justice is a part of the governing norm of any executive government or the governance of the country. So in every walk of the justice in every walk or sphere of our life, justice should provide. So it is for the youngsters to think it themselves and taking up the staff of use of technology for the rendering justice to the people. This is the second take on this point. The third take is on the collaborative approach from the adversary. We have been following an adversarial system of dispute resolution, primarily based on the Anglo-Saxon jurisprudence. Our country and culture is not, in fact, is rooted on basis of is not rooted to the adversarial approach. In fact, the country's culture and tradition always speaks about creating a relationship among the members of the civil society or society. So in an adversarial approach of dispute resolution, there is always an hostility is created, a kind of agony that comes out of such an approach. What we need is a kind of a collaborative approach, either through mediation, conciliation, whatever the form of it could be advanced. So future of justice of this country is looking for a dispensation based on a platform where it can create a collaborative approach in settling the disputes, not based on the adversarial approach. So these three areas, I would say, it's a big challenge to the youngsters. They have honest duty and responsibility to take challenges forward. The future of justice would certainly depend upon three aspects as a book. So with this word, I conclude and I open this for any debate and questions. I'm here for answering it.
Thank you. The insights given by you. Somehow you have got it muted. I will just unmute you.
Challenge is through the technological in the form of technology.
Right.
Yes.
So we will be unmuting Sujoy, who just, as they say that there is an advertisement, we had him as a failure because he's a part of all our thought processes. He's from Bombay. He's a good lawyer out there. So he acted as a filler like the advertisement break when you went outside, and then he just asked him to chip in. So the thought, whatever we had a talk from your side, the dialogue given by you, one concept I am reminded when we were in 10th, there was one word which used to be commonly phrase which used to be there, old order changes, yielding place to new. So the yielding to place to the new would mean that according to you, we have to change to the technology, collaborative arrangements, as well as the thought process. But in fact, so you would have also seen the way the technology has changed within the profession itself is challenging. I remember when we joined in the bar, etc. At that point of time, they were typists. Then we were shifted to MS, WordStar, then MS Word, then the computerization, networking, and the way the law is being researched. Earlier, it was the books. Then it came to the some CDs, etc. Then we had keys. Now online search. Take all these. What way you have helped the Kerala bar? How we are using the legal technology innovation to that. We will also take the questions which are being posted in the group. And in the session, it was quite intruding also and encouraging also to the effect that you took cues from the American law, Californian law, and that's why it shows when we go through your resume that it speaks of the volume that you have delivered the paper in different aspects. So you just give your take and then we will start taking the questions.
Good evening, Your Lordship. Greetings from Mumbai, which is Corona hotspot, unfortunately. But about 4 years back, I had the privilege of appearing before you in Cochin High Court in a tender-related matter. And I took back a lot of stories about Kerala High Court back to Mumbai. The spacious courtrooms, the cordial bar, and they were very pleasant memories.
Cordial
good
judges
evening once
also.
Yes, absolutely.
That should not miss that. Yes.
Absolutely not. And that is what I came back and told all our brothers and sisters in Mumbai, that one visit to Cochin High Court is very important. The whole atmosphere is very cordial. So what was very important and striking, Your Lordship, today were that you emphasized on the institution. We will come and go, but the institution will remain. And confidence of the public is most important to be maintained, apart from the majesty of our courts. Traditional values and traditional rules have to interface with modern written law. And if we forget our traditions and our past and basic rules which existed, then we will be missing the point. One example is that we could never imagine that we would have to have parliament to draft a law to maintain our parents or elders. We see that very sad part where, in fact, day before yesterday, I was on virtual conference in Bombay High Court, and there was a case where a daughter filed a suit against the mother and other siblings, and it was for a flat, and the daughter wanted to stay in the flat and evict the mother from the flat. These are instances where we forget our traditional values, and we have to have acts where we have to remind ourselves that, look, elders who are next to God in our life, you are obligated. And therefore, it is very crucial and important takeaway from your talk today that we must never forget our traditional values. Modern laws will come and go, but our traditions will remain. Apart from that, the use of technology, which you emphasized. Technology is a part of our life, our genes and DNA now, and it is a very useful tool. I thank you, sir, once again for enlightening us. Over to you, Vikas.
Okay. Professor R.S. Taru asks, though prima facie review of our constitution, is it mandatory to secure and preserve the socialism by state machinery? What is your take on that?
See, the question of socialism, I don't think at distance of time, as propounded and elsewhere in theoretical, could be put into practice. But idea of socialism is essentially related to the fair distribution of wealth and office. Even Rawlsian idea of Rawls' theory of justice speaks about kind of agreement between and the people as a social contract for the fair distribution of wealth and office. In that take, it's for the political masters to answer those questions of fair distributions. But nevertheless, court should not forget their role while interpreting many of the law related to the economic rights. There are empty number of occasions we see that in the courtrooms, how the people are deprived of their homestead, valuables, whatever may be, on account of some kind of policies being evolved for the protecting the interest of the bank, financial institution, etc., where we need to strike some kind of balance. Maybe in a socialist principles, we may not be able to adopt as such. That's what I feel. Kind of system where we follow the mixed economic policy, larger now overwhelmed in the more capitalist ideals. This is a political question to be answered, where I cannot answer straight away, except to the relevance of in a contextually in a dispute.
Right, sir. So before we take the question of Kumar Eswaran Rangoon, I'm reminded that the time and again you said that the young bar has to take all these things forward. But I am reminded in Punjab Haryana High Court, they say there are only 3 types of lawyer: young, very young, and youngest. So all are young and vibrant, because as long as they say, because the lawyers never retire, because the thought processes, and we have seen the Attorney General celebrating his 90th birthday and moving things forward. So they say, as long as you are fertile with the ideas which are for the betterment of the society. So one would always be young, and for law, you have always to be tuned in the right fashion to be in a good way. Because they say the mind is like an axe. If you don't sharpen it daily, or you don't use your tools in the right way, somehow or the other you will be out of the market. People will look forward for other professionals. So Kumareshwaran asked, could you please explain as to how inquisitorial system would help us better than the present adversarial system in vogue?
Yeah, inquisitorial system, some of the countries follow the inquisitorial. I think Japan follows the system in criminal law, so which would help them to ensure that 90%, more than 90% of offenders are convicted or sentenced. We are following adversarial system largely based out to the Anglo-Saxon jurisprudence. It is time for us to change, especially in the criminal law, where the inquisitorial should know that where the role of investigator or the judge is not like a neutral umpire. They will have an active role to find the truth. That's very, very fundamentals of the inquisitorial system. In adversarial system is like Pound referred in sporting theory, where his judge is like sitting like an umpire in a football match. He just stick to the rules of the game. He just see that both teams stick to the rules, and he is least bothered about outcome if whoever wins or lose. It is not something which he cares about. But in adversarial, in inquisitorial system, the judge or investigator will have an active role to find out truth. Maybe in criminal cases, we may require a certain extent an involvement of both well as the judicial system as well as an investigation authority being put in under one umbrella, so that they just inquire into the truth of the issues. I'll just make certain comment on the inquisitorial system. Recently, I come across an issue, like you referred on referred to the Senior Citizens Act. You know that we have a Senior Citizens Act in the place to protect the Senior Citizen Act. This is being handled by some revenue judicial officers or by kind of executive officers before whom this complaint is filed. So the lawyers are trained in adversarial litigations. Their mindset is always in adversarial litigations. the quasi-judicial body or body which takes up the matter also been trained in the same fashion. They just look up upon the criminal procedure code, they look at the evidence act, and they decide things as though they are an impartial arbiter. But this approach has to be made in contextually. In the Senior Citizens Act, Domestic Violence Act, where the inquiry which is required is like an executive system, because focus of those inquiries is to protect senior citizen or in women in the domestic violence. I think we are not very conscious in creating the different subtle difference between adversarial and inquisitorial system in our approach. The lawyer community as well as the judges who are deciding this causes also are not aware of these differences. As I said, in the adversarial system, you are a neutral umpire, you have no role, you just stick to the, your role is to see that both teams stick to the rules of the game. In inquisitorial, you have an active role to find out and promote the truth. Yes.
So the questions are not there, but since you have been widely connected with the latest technology, and especially in the era of the COVID-19, since we have participants not only from Punjab, Haryana, like Sujoy is from Mumbai, you are from Kerala, we have participants pan India. So what are the things forward, because every student of law as well as the lawyers who are practicing, or for that matter, judicial officers and the judges, since we all read it in the newspapers and also saw it on the YouTube, that you had all promoted the ideas of virtual platforms under the aegis of Honorable Mr. Justice Chandrachud. What are the new issues and methods you have taken up which will facilitate the filing or taking up the issues during this virtual platform and beyond?
The fundamental issue in the virtual platform is the infrastructure facility we have. There is a dearth of facilities. That in fact stands an hamper or as an entrance to the rendering justice. The connectivity is now we face is a simple issue. The kind of application we use, the kind of transmission which is has to take place through the electronic mode, which are the kind of infrastructural logistical issues we face. That is really worrying factors. Now, first and foremost, focus for us on the virtual court to create a virtual court platform to create a sustained, a very robust infrastructural facility in a place. So that will take things in its own shape. Now, I would say that virtual platform is not a real substitute for the physical platform. In a physical, you know, the kind of space we have in a virtual platform is not that exhibiting, it is not that thrilling as you could do in a physical platform. But virtual platform certainly would find a place as a aid in the process, in a sense, to help in the place where we have no other system to decide such kind of disputes. So in Kerala, what we have done in the High Court, immediately the lockdowns clamped down. We have decided, because constitutional court cannot close down. Its door must be open to all, because it is one of the pillar of the state, and justice always is it doesn't have any time bound or time constraints. The justice is always issued the concern of the institution. So we immediately, without looking into any other consequential impact that may have upon our decision, we decided to start with the email filing of the cases. But slowly we developed into, now we have a very robust e-filing module through the bail. We are slowly moving to the e-filing module so that it would create a sustained platform for filing at least. We have also video conferences cases, video conference being scheduled through the online module, and a couple of the courts are now hearing the matters through video conferencing. Now, as a person being the chairman of the committee here, I would say in a period like period like this, like in COVID or pandemic, this is a good platform so that people would not be deprived of justice. In normal course, I would say this should not be taken as a substitute, except for e-filing. The video conferencing should not be taken as a substitute for physical hearing. And secondly, I would say the there would be a large class of lawyers would be excluded from using this facility because of they may not have the laptop, they may not have the wherewithal, they may not have kind of infrastructure. So that itself will become a casualty of justice, because when you're excluding certain type of lawyers or people who could not afford, that itself will become an injustice. So we should have a system in place to take them in also into the fold, so that there could be any room for any complaint of injustice being meted out to such persons who are feeling that they have been marginalized or excluded. Yes.
So Bala says, how can we secure the faith of a common man when the court acquits the accused on the ground of bad investigation? What are your takes? How to nip this bad investigation, etc.?
Bad investigation.
Yes.
I think courts having some power. I'm not very conversant with the criminal procedure code, but court is having power under 173(8) or something like in criminal procedure code for reordering reinvestigation. Court should have an active role, seeing that proper investigation is conducted. And Supreme Court has, I forgot the citation. It is reminded that is a power is vested with that court. Use 173(8) subject to correction in appropriate cases.
We would be unmuting Sujoy. Sujoy is an expert on the criminal law. Sujoy, your takes on that?
No, I agree with his lordship. 173(8) supplementary charge sheet. The power, the court, the prosecuting agency always asks the liberty of the court to file a supplementary charge sheet for further evidence.
His question is that once there is acquittal, 173(8) would be on a different pedestal. He says there is an acquittal because of the bad investigation.
No, if the judge senses that the investigation is bad, 319 allows him to issue summons. 319 also allows him to reframe the charge. 319 allows that freedom which a court has got at a trial stage to pass all appropriate directions and orders. If the court senses that there is some mischief somewhere, and if the court finds, court is not helpless at all. But if all this is ignored, and if the verdict comes in a person's favor because of bad investigation, I feel it is a miscarriage and travesty of justice.
As Joy said that Sagar Kole has already given the has posted on the judgment which Justice Mushtaq was referring. Vinubhai Malviya versus State of Gujarat. We are thankful to you, Sagar Kole, for giving the right insights. So, but be that as it may, we were just asking that we are since planning. We do not know till what time this lockdown will go. But what are the key points which you have taken in the virtual platforms, which other courts could emulate that and move forward for the purposes of filing, etc.?
See, first and foremost is a confidence of the bar. That's very important in any initiative. When you're making a shift or changes, without their support, you may not be able to take forward things. The moment we have decided to use this online platform through video conference, we call the meeting with the bar members. We trained them through the Zoom. So they have apprehension that it may not be this platform and is not a user friendly, has vanished by the time they were trained. So they were much confident. Now the bar demands, because there was last week there was an instance of one policeman came to the High Court as a reporter to have infected with COVID. There was some panic among the lawyers. The demand is for a virtual court instead of physical court. So we have reached such a stage where lawyers themselves demand for a virtual courts. Now the 2 points is as far as the lawyer community is concerned. One is there should be infrastructural facilities. If there are lacking infrastructural facilities, there should be a place like E-Seva Kendra. E-Seva Kendra is something like advocated by the committee of Supreme Court. They asked every High Court, every district centers to provide E-Seva Kendras to help the litigants as well as lawyers for filing cases through online, and also help them to understand the process involved in through the video conferences. So this is one area where we should focus. We should ensure that every lawyer and every litigant who were even out effort are included in the process. Secondly, the platform we are using. Kerala High Court, I think, the only High Court using the Zoom platform. Because of some prohibitions, restrictions have been placed by the central government, all other High Courts and other, even including Supreme Court, they're not using the Zoom. We don't find any other platform is ideal and conducive for hold the Zoom, video conferences. This is a very tricky issue because we need to have a kind of application which is user friendly, which is sophisticated, which would enable live streaming of the court processes. So choosing this platform is also one difficult. And as far as we are concerned, since we have used Zoom, we don't find any, so far we are not finding any issues in conducting video conferences. But some of the courts find still a difficult, they have faced some challenges because of they use some other platform. And Supreme Court appears to be resolving this issue by taking some license of some of the applications. But we need some common platform for all high courts and district courts for use.
So in the Zoom application, I will just explain, since we have been holding webinars, and probably today would be our 84th or 85th webinar, because we are doing back-to-back webinars. I have just not even taken the note what webinars we are on. But in Zoom now, they've also come with a common platform. Like today, you could log in into any meeting today directly. But day before yesterday, only I received the mail from Zoom. They said you will not be able to log into any Zoom application until unless you update your Zoom application, number one. And number two, until unless you register yourself, meaning thereby you have to register through a form or a mobile number. That takes two events. It caters to two effects. Number one, that your hacking of your platform will not be possible, because we held one of the webinars. We found that there was a difficulty in that. There could be a hacking because some people do hack in with different login. So that preventive measure, Zoom is also working on that, and other platforms would also be working. So
I think they are updated security features.
Yes, security features, but they said that they will start taking it from 15th of July, I suppose. I will just check it on the mail. I just received it yesterday only.
But any online platform is vulnerable, according to me, as being a person who's now intermingling with that. Any platform is liable because is vulnerable. So features, security features has to be secured by the users themselves, not by others. So every person has to safeguard themselves by storing their personal data in the computer, laptops, whatever medium they may use.
They have sent the mail yesterday, day before yesterday. It says now new updates for the Zoom application would be setting to disable emails and login IDs. Let's assume somebody wants to log in through the email, that won't be allowed. Then it says configure whitelisted domains for bypassing the waiting. And then unmute all for meetings of 200, that you could unmute in one go. And setting to disable the participation annotation. Because what happens is sometimes there is a screen sharing and sometimes a spoil sports. Not maybe in these platforms invariably don't do. But sometimes while screen sharing, some people play this thing. And manage virtual backgrounds, because sometimes one doesn't have that background, but he can use a virtual platform. So before we end up, one Omkant Shangumantan asked, how do you address the privacy pertaining to security?
Private security.
Yes.
In what context is asked? Any
Probably, I think it's an offshoot of the Zoom application. What we are saying that, how do we do that? Because as a lawyer, it's a fertile brain. As soon as you take up something, immediately a question shoots up.
Maybe can you ask the question of
he has clarified. How do you address the privacy pertaining to security Zoom application?
Privacy is something is a relative term. In a context of conduct of the cases through hearing, by court hearing in the platform of Zoom, absolutely there is no privacy involved. The court itself is expected to work in an open platform. So there is nothing to hide except the cases where it is need to be masked the identity of the victim or applicant in whichever cases. In such cases, safeguard has to be made. So in a courtroom where it is working on an open platform, you can't expect to have some other privacy. If you are logging itself, you are declaring that you are open to public domain, and you will be viewed by others as well.
That's true. Yes, sir.
And transmission of personal data, of course, it may be a tricky issue, like identity of individuals. We don't have a law in our place in regard to transmission of personal data, unlike in European directives where it works, how a personal data could be transmitted from one platform to other, how an agency can transfer personal data of individual to others, and what manner it has to be filtered and dealt. We don't have a law in regarding to the personal data protection, except the declaration of law by the Apex Code in regard to protection of privacy. So it is a privacy question is always relatable. By your own conduct, you making yourself open to viewed by public, or my details are open to the public. There itself you compromise the very idea of protecting your individual identity coming from the open platform. So you can't blame the system provider like court, which provides an open platform for hearing a cases. Yes.
Right, sir. So the point well taken, because there are a lot of discussions as to whether the live streaming of all the discussion should be there, and Zoom would be still restricted unless you go live on the Facebook, just like what we have done. Otherwise, invariably it is restricted to the participants, and participants are invariably those persons who have their cases or who are login. One of the issues, sir, since we are doing a lot of webinars, one person suggested that you can create another email ID wherein you don't refer to your accounts to the effect your personal transactions, so that let's assume somebody wants to peep into it, he will only log in through that ID which only caters to the virtual platform, etc., etc. So he said that you create another ID, and that's what we did initially. We shifted from our personal ID, we created to a Beyond Law email ID, so that there's nothing except that the webinar is there. So the points we have well taken, that as you said, that the bar and the bench, they all say that they are the two sides of the same coin which have to work in the better functioning, and they say it's the teamwork, and teamwork, as we all know, it means together everyone achieves more. So it is the united effort of the lawyers, judges, and the litigants who have to work together. So thank you. It was a fascinating session. We got all engaged in a different flip. When we actually had a topic, that is when we decided to have a topic on the legal system, etc., law, judicial process, and justice. The thought was as to how we will move forward. But your insights to that topic, that what is the judicial process and how we have to tune with the time, that was a point well taken. Tomorrow we have a webinar again, but tomorrow it will be at 4 p.m. by Mr. Manokran from Madras High Court. He will tell us the facets as to what has to be taken into and what are the grounds, etc., to be taken during the appeal, civil appeal of CPC, that is section 96 and 100 he will touch. How we can take part of the pleadings, evidence, how it has to be appreciated. So since Symbiosis Law School Pune is a knowledge partner, we have Garima Pawar, who is working in Symbiosis Law Schools itself. Before I formally ask Garima to propose a vote of thanks, all participants, we are obliged who are taking keen interest on the webinars conducted by Beyond Law CLC with our knowledge partners, earlier ULS Punjab University Chandigarh, now Symbiosis Law School, and these webinars which we conducted as solo of Beyond Law CLC, because the entire intent is to transmit knowledge from the classes as well as masses, so that everybody could be enriched. Thank you, everyone. Stay safe and stay blessed. Over to you, Garima, for the vote of thanks on behalf of Beyond Law CLC and Symbiosis Law Schools.
Thank you, Vikas, sir. On behalf of Symbiosis Law School Pune and our director, Dr. Sashikala Gurpur, I would like to express my sincere gratitude to Honorable Justice Mustaq and
Thank you.
for sharing such an immense experience with us. And it was such a stimulating session for us. I'm sure the participants over here and all the young minds would be inspired to think upon, to ponder upon advancement of arguments, and to move ahead of the traditional approach which is there, and to come upon a balanced approach. In the age, we are living in the age of artificial intelligence, and thinking upon how we need to adapt to the legal process, the justice delivery mechanism. We need to adapt somewhere or the other to the technological developments which have been happening around. So you so beautifully portrayed the concept of niti, nyaya, and its consonance with democracy. It was indeed an informative session for all of us. Also, a special thanks to our knowledge partner, Beyond Law CLC. Thank you, Vikas sir, and all the participants. Have a good day ahead.
Thank you. Thank you, sir. Everyone
Thank you.
stay safe
Thank
and
you.
stay healthy, sir. We will look forward for another stimulating session from your side.
Okay.
As we
Thank
said,
you.
and I can vouch upon that what Mr. Giri said yesterday, and in fact, in one of the messages, one of the judges who had come on our platform, which you were referring to, doctrine of proportionality, he was sharing that you are bringing some judge who will give you the insights which invariably you can have from a person who has good knowledge on all subjects. Thank you, everyone. Stay safe. Stay safe. Thank you, sir.